10, the Fayetteville City Council is looking at repealing an ordinance they just passed to help with its housing crisis because they worry it could violate state code. It's a quick about face just months after they took a big step to help renters in the city save money. KNWA's Casey Smith joining us live. The city attorney told you why their ordinance that would have capped rental application and background fees already needs to be repealed.
Yeah, that's exactly right, Doug. Fayetteville City Attorney Kit Williams and Arkansas Attorney General Tim Griffin both agree that the new ordinance that would put a cap on rental application and background check fees likely violates state code just because of the rental, the goods, and the services aspect of things that can't be regulated. The key word there being services. Here's why. The city of Fayetteville has been dealing with a declared housing crisis since April of 2024. One problem with housing on the Hill that council member Sarah Moore identified was the cost associated with rental applications and background checks that could stack up on potential tenants.
She had heard that this could be very expensive for a lot of renters, especially if they had to apply for more than one, and that she felt like some of the charges that she had been reported to her were too much, and so she thought we should try to regulate that.
That led to the drafting and passing of Ordinance 6800, which would limit rental application and background check fees to a maximum of $40. However, after further review from Fayetteville City Attorney Kit Williams, he found that putting a cap on rental fees likely violates Arkansas Code 14-43-608. He brought it up to the City Council in December to repeal the ordinance, but there was some opposition.
They wanted to get Attorney General's opinion, so I said, fine, and let's just extend its effective date until the end of March so that we make sure it does not become effective if it's illegal.
Arkansas Code 14-43-608 bars municipalities from regulating prices for goods, rentals, or services sold or performed within the municipality by individuals or firms.
Well, services is a very, very broad term, and I believe that the courts would very likely say that reviewing an application is a service that the landlord is providing to the tenant, and therefore we cannot regulate the cost of that.
And a few members of the 95th General Assembly agree. State Senator Clint Penzo of Springdale drafted Senate Bill 91, which states that local governments would be unable to regulate how much is charged for a rental application fee. One of the co-sponsors is State Senator Joshua Bryant of Rogers.
This is really in response to something that we did see Fayetteville do, and while I applaud them at looking at the cost of housing, I'm just not a fan of getting in the relationship between private businesses.
Bryant believes there are other ways to protect renters in the natural state.
But I think those can be addressed through deceptive trade practices and consumer protections rather than just putting a blanket fee cap on that relationship.
And Williams says there could be legal action taken against the city if the ordinance isn't repealed.
We could get sued, and we would get sued, and there would be allegations that we are violating the state constitution, which also talks about having city ordinances not conflict with state law, and so they could try to get attorney's fees and things like that.
Williams says that if you disagree with this ordinance being repealed, to reach out to your local state representative. Reporting live in Fayetteville, Casey Smith, KNWA Northwest Arkansas News.